Hello, everyone. My name is Leah Nyland. I am a reporter with Bloomberg, and I have spent the past 14 years covering antitrust. I have a great panel today. We're going to talk about the U.S. litigation that has been ongoing against the tech giants. Thank you guys all for staying to the end. We really appreciate it. I had persuaded my panelists that you guys put us here because we're actually the most interesting, and it would get everyone here to the end of the day. To my left is Michael Kaitis, most recently of the U.S. Department of Justice Antitrust Division. Before that, he worked for Senator Amy Klobuchar, who has spent a long time until this year as the chair or ranking member of the Senate Judiciary Antitrust Subcommittee. To my right is Laurel Kilgore, who heads policy at American Economic Liberties Project. And then to my far right is Michael Schwartz of the New York Attorney General's office. So we have Michael K and Michael S. I will try and keep that straight. We're going to go over a bunch of the cases that are pending against the tech giants, but we are going to probably end up spending most of our time on the cases against Google, simply because those are the ones that have been litigated the farthest. But to start, we're going to talk a little bit about a case that the Justice Department filed last March. While I had pneumonia, I was not very pleased by that. US v. Apple. So Michael Kaitis, why don't you tell us a little bit about that litigation, what the Justice Department is concerned about, and what you guys are hoping to remedy?
Okay, it looked like the green light was on. Not a good way to start talking about a tech case by having basic tech problems. But obviously, I am no longer at the Justice Department. So the Apple case really, I think the best way to sum it up is to actually look at what Apple's internal document said, is that Apple was concerned that their business model was they made the iPhone and the iOS, and it had a very unique brand design vis-a-vis Android. It provided better protection. It was easier to use. What they worried about, what at least according to the complaint, their worry was that as technology developed, somebody could, through the cloud or other ways, basically give you all the advantages of the iOS without having to have the iOS phone, and therefore you would commoditize the phone. And there's literally a document where, like, what we're worried about is if there are various ways where we'll get to in a minute, but saying that all that we would have left is the phone itself, which would be like, no different than a cheap Android phone, and we would be able to price. And so what they were worried about are various things. One would be, as we point out in the complaint, if there were alternative app stores that could curate in different ways, that would allow people to if you had an iPhone, not necessarily, you could it'd be easy to switch to Android, or in the face of that would cause Apple to have to compete more vigorously on price. They were concerned that, for example, their NFT antenna, which is what they use for Apple Pay, again, if they allowed other people access to that, it would make the iOS less important. And because if you can only use Apple Pay, then if you wanted to, it's harder to switch to Android. But if it was actually, say, Bank of America Pay that worked on both platforms, it becomes much easier to switch, right? And even something as arguably trivial, you might say, right, is that, but that has actually reached meme status, right, is how Apple uses messaging, which is, and I, as someone who has an Android phone, amongst a bunch of other antitrust officials who did not, was roundly criticized. If we were texting, I got the green bubble and got no emojis, and they would, Doha and Jonathan would make fun of me. But and you say, well, is that a big deal? But here's the thing about that really interesting, is at least from my perspective, was Apple was making the messaging system worse for even Apple users. Like, why would you do that? And we could talk to Steve Jobs made it clear. He was asked once about this. And the guy's like, look, my grandmother, she's got an Android phone. It's messaging's all screwed up. And his response was, you should just buy her an Apple phone. Right. And so the theory behind the Apple case is Apple has done all these things unrelated to competition, the merits, that have basically created a wall around its operating system phone monopoly and preventing any form of competition unless somebody else is going to come up and develop a new whole system that is neither Android nor Apple and does what Apple does better.
Laurel or anybody else you guys want to make any comments on this one? This one was joined by a number of state attorneys general. It's still in the very early stages, though. I think they had their motion to dismiss arguments last year. The court still hasn't ruled on that, but we're probably a couple years out because, as I should have mentioned at the beginning, antitrust litigation in the United States takes forever, which is how I stay employed. The next case we're going to talk about is actually one that was filed by the FTC in 2020, but is soon to go to trial. So, Laurel, why don't you take that one?
Okay. So the last panel was talking about the Trump effect, and there are many different Trump effects that we're all still trying to figure out. But one of them is that the very first big tech cases of the modern era were filed at the very end of the first Trump administration. And one of them was the FTC case against Facebook, now Meta. So that case has been pared down. There were originally some other anti-competitive practices, but now it is just Section 2 monopolization case focused on Facebook's acquisitions of Instagram and WhatsApp, so monopoly maintenance case. So the Instagram transaction happened in 2012, billion-dollar transaction, huge headlines at the time, very rushed through transaction. I think famously, it closed in a weekend, it was a very dramatic situation. Also got a headlines because Instagram only had 12 employees or something. So that was the sort of motivation for that was that, or the context for that was that Facebook had been, something that came up during the desktop era. You accessed Facebook through your desktop, and we were going through this transition to mobile. And in reflection, Mark Zuckerberg said it was a very dangerous platform transition. We were very vulnerable. Other companies kind of failed to make that leap. And so Facebook was looking at Instagram. Instagram had just launched its mobile app, had just raised a $50 million round. And they were going to use that to, quote, build an army of engineers. So the allegation in the complaint is that that was what was the true motivation, was to control, neutralize this potential nascent competitor rather than anything about making the platform better for users or advertisers. For the WhatsApp transaction that was in 2014, that was perhaps emboldened by not having been stopped to acquire Instagram. That transaction was for $19 billion, even more. And that was the context for that was that Facebook was looking at what was happening around the world. And it saw that in particular, WeChat had started with a messaging platform and then was able to use that as a springboard to launch a competing social network. And Facebook was looking around in the US and saying, WhatsApp is starting to get traction. Maybe WhatsApp will do the same thing in the US. If they get enough users on their platform, they can then use that as a launch point to compete with us in the United States. And so that's the allegation of why they acquired WhatsApp. So the initial complaint filed under the Trump administration, that complaint was dismissed with leave to amend. And you can kind of see the mentality of kind of the era of antitrust enforcement that was very focused on, short-term price effects. because the judge said, okay, you've alleged there's a 60% market share in this thing that you called a personal social network market. Not really sure what that is. Maybe that would work in, just be barely sufficient in, a standard market that, judges are familiar with, but we're kind of in this wild west of the internet. You're going to have to show me more. It's weird to me that this is a free product. I don't really understand this. So he said, you have a speculative and conclusory assertion about the market share. You're going to have to go back and do it again. By the time they had to amend the complaint, Lena Khan was chair of the FTC, filed an amended complaint to get over those Iqbal Twombly kind of pleading defects, and was able to persuade the judge, oh, there is something here. We can allege that there are harms to service quality, privacy, innovation. There's this other way of looking at it. We have, a market that we've defined, including Snapchat and MeWe. Facebook obviously says it is much broader. Facebook saying it includes Twitter and YouTube and TikTok, very, very broad. So that case survived the second motion to dismiss, survived summary judgment. And in that opinion, the judge remarked, how times have changed. 15 years ago, there was a movie called The Social Network. Now Facebook even disputes that that is a cognizable market at all. So that case is about to go to trial starting in mid-April.
Yes, that's where you can find me in all of April. The interesting thing about that case is at the same time that the Trump administration filed it, a group of state attorneys general led by New York also filed a complaint. Unfortunately for New York, that complaint was tossed out under essentially the judge said they had waited too long to bring the case. That was affirmed by the DC Circuit. So for now, the only agency that is going to trial in April is the Federal Trade Commission. The states were not able to continue pursuing that one. The next one we were going to talk about is actually our private, well, it started out as a private enforcement action, but it later did involve the states. So I think we were going to have Laurel start with this and then we'll.
Okay, sounds good. So Epic. So the origins of this case, well, the origins, depending on how you want to think about where the conflict started, arguably could have started when Apple and Google imposed 30% take rate cuts on every digital transaction through their platforms. But it definitely started in 2020 when Epic Games, the maker of Fortnite, launched what it called Project Liberty, which was it gave Fortnite players a code so that they could go and directly buy things in additional in-game features through Epic rather than using the App Store billing methods from either Apple or Google. Of course, Apple and Google were not very happy about this because it was a violation of their terms of service, and they kicked Fortnite off of their app stores. And Epic then turned around and sued both Apple and Google, but in separate lawsuits. And they got different results in those different cases. So the Apple case was heard first. It was heard by a judge. Epic mostly lost to that case. So in terms of sort of the color commentary, the judge was, I think, somewhat unhappy with kind of Epic's character. The judge was not happy that Epic had kind of sneakily gone and built in these features to evade the systems. And Epic had launched a very kind of showy, in the judge's view, maybe arrogant campaign where it had a commercial that was making fun of Apple's famous 1984 commercial and casting Apple as Big Brother as the villain. It also came up with a video game avatar character that was making fun of Tim Cook. During the litigation, Epic's counsel made some decisions that I think the judge also viewed as a little bit arrogant. So there was that kind of color in the background. But in terms of the substance of the case, the judge actually decided on a market definition that I think was different than what either party proposed. She decided it was digital mobile gaming transactions, which was different than either party. Epic had, of course, argued for just, Apple's own app store as sort of the scope of the market. But even within this kind of broader market, the judge did find that Apple had a 55% market share, which is very significant, found that Apple had very high profits. But the problem she found was that Epic just had not come forward with enough evidence to show that there were barriers to entry, that there was reduced output or reduced innovation. She said that it wasn't impossible that there had been a violation, this wasn't as a matter of law. It was just that she didn't think that the evidence on the record was sufficient. So on most claims, Epic lost. Epic also lost in the counterclaim because it breached the terms of service. So it had to pay Apple 30% of the fees that it had collected through that gambit. But Epic did win on a California unfair competition state law claim for its anti-steering provisions, where it basically was Apple had prevented Epic from telling developers, hey, or it's telling users, hey, you can get this, somewhere else. You don't have to only go through Apple billing for this. So the judge issued a very short, like 1 paragraph injunction that said that you can't, Apple, you can't you can't prevent developers from communicating with their own customers about other payment options. And Apple, in Epic's view, did not comply with that injunction. So Epic filed a motion for sanctions. And I think this was happening around the same time Apple was starting to do what people are calling malicious compliance to the DMA. That kind of happened first. And then Apple filed, Epic filed this sanctions motion. There was a hearing, and somehow that has, case management wise, gotten very messy and turned into almost a year of discovery. So there's this kind of sanctions hearing that was kind of hit on pause, and then a whole bunch of discovery. We are finally going to get to the rest of the sanctions hearing in late February, we think. And in the meantime, because that wasn't enough drama, Apple filed a motion to set aside the judgment, which is pretty an interesting tactic after this had already gone up to appeal and been affirmed, and the Supreme Court denied cert. After all of that happened, Apple is now trying to set aside the judgment based on some intervening case law. So there is a lot going on here, and it is finally going to get back to a substantive stage soon. So that's just the Apple case. I can talk about the Google case.
Yeah, Michael, I wonder if there's anything you can say a little bit about how the Justice Department is approaching its case against Apple differently than that Epic.
Well, after that summary, hopefully better. Look, I mean, I think this raises the interesting thing about what's going on in the United States litigation is you have the tech companies are facing an assault from all sides. So you have Epic, a fairly large company itself, mounting its own Section 2 claims against 2 of the largest companies in the world. You have the state attorneys general involved in their own cases involving these companies. In addition, and then you have the federal enforcers. If you go back, it's been a long time since you've had that kind of attack of such a broad-based litigation assault. And we're getting to the point where we'll see how effective it has been. I mean, obviously the Justice Department won on the merits on the search case. Who knows? Somebody should check. Maybe we got the bad tech decision while we've been sitting up here.
I've been watching.
Okay. All right. If they are, I'm not going to comment on the decision without having read it. But so, right. And, so, I mean, Epic as a private company has a very specific goals in mind that as a company that may be consistent in some sense with the government, but doesn't necessarily, they don't have to be the same, and they can overlap, and there may be some tension. But I think more generally, to get to your question finally, I think the government's perspective was we saw a market where Apple had effectively isolated itself from competition writ large, and that was a problem we thought a public enforcer needed to deal with. Right? We weren't just focused on the 30%, or on, rather it was how was Apple really preventing new forms of competition being developed. Now that's kind of part of what Epic was worried about, but for them, right, the issue, the business issue proposition was they were really ticked off that Apple was taking 30% of every transaction on their game, whereas for us, it was really about a much more sort of broader assault that, look, that Apple has created this wall around its products, and that it's not just the 30%, it's not just one thing, but you need to look at how they have developed across over time. All of the, not all, but much of their development is really more about making it harder for people to leave Apple rather than making Apple more attractive to stay.
Go ahead, Laurel. We're going to switch to Epic v. Google, which is the other one.
All right. So whereas the Apple case was heard by a judge, the Epic's case against Google was heard by a jury, and very different outcome. I think the jury verdict was made very quickly, within just like 4
6 hours.
Yeah, very.
I thought it would take
quick.
them longer, and I had gone to lunch.
That was very rude of them. They should have given you a little bit more time. So Epic totally won that case. The market definition was different in this case. So it was one was a distribution of Android apps, and the other one was in-app payments. So the jury decided the liability phase, but the case was bifurcated. So there was a separate phase to determine remedies, and that was heard by Judge Donato in California. And so in addition to saying that Google can't require the use of Play billing in apps, there were some remedies, and this is what largely what Epic requested, although for a shorter period of time. So it was basically remedies to kickstart competition in app store markets so that Epic could have its own app store that could, host games that users could download, or Amazon could have an app store that would be distributed. So basically to foster competition in the app store market. So that would, in order to kickstart that market, the idea is that those app stores could be distributed on Play like any other app. So you would download the Fortnite app store through Google Play initially. You would download the Amazon app store through Google Play initially, and then proceed as normally. And also to get over sort of the initial chicken and egg network effects, those app stores would, for a short period of time, be able to have access to Google catalogs, Google Play's catalog of apps, to help them get the initial scale that they were needed, because part of the allegations is that they were denied scale. So that's the remedy. It was shorter than what Epic requested. Epic wanted essentially something like 5 or 6 years, which would be 2 cell phone replacement cycles. Judge Donato settled on only 3 years, which would be 1 cell phone replacement cycle. That case is currently up on appeal. So mostly the remedies stayed. There is one part of sort of the contractual restrictions that is in effect, but most of the remedy is stayed. The appeal was expedited and combined, so liability and remedies heard together. That just happened within the past week. The panel, so the main argument for liability that Google is pressing on appeal is an estoppel argument, saying that, hey, there was this very unfavorable decision in the Apple case. Apple also involves app stores, so it's inconsistent that we have a different result in this case. The judges from the panel, it was a 3-judge panel. Each of the judges seemed very skeptical, asking questions like, okay, well, if that's true, why, Google, did you never try to combine the cases from the beginning if this is so overlapping and intertwined? Why didn't you raise this earlier on summary judgment? You didn't even raise it on summary judgment. You came up with it very late on a motion in limine. So that's sort of, they seem skeptical on liabilities. On remedy, the contention is that the judge should have done more analysis to show that there was a significant causal connection between Google's conduct and the kind of ill-gotten network effects. And the other aspect of it is that, as for what the substance of the remedy is itself, Google, and this is kind of a preview of what Google is doing in its other antitrust cases, is Google is saying that the Trinco case, which is about refusals to deal, it's a liability phase case, but Google is saying that this should apply to remedies. It's trying to say that there's some kind of policy that the, United States doesn't want to have any kind of remedies that involve sharing. Counter argument to that is that, well, in the past, Microsoft was required to share its APIs in a case. And Trinco, again, it was a liability-based decision. You can require a wrongdoer to do things that you could never require an innocent person to do. So, if someone has been found guilty of something, they can have, you can make them spend a night in jail, you can make them do community service. You can't make an innocent person do that. So of course you can make remedies, require a wrongdoer to do something that an innocent person could not.
So the interesting thing about the Epic case is a little bit after that case was filed, the state attorneys general also got into that. So Michael, can you tell us what was interesting to the states about that?
So in addition to Epic, obviously, are private companies suing Google based on how it ran the Play Store. Initially, 39 state AGs also sued Google, and the cases were consolidated. It was later extended to all 50 states. There's also a consumer class action, and we settled with Google in October 2023. Our settlement calls for Google's agreed to pay $700 million to consumers. We have a number of strong injunctive provisions, including allowing sideloading of third-party app stores, Google not restricting alternate in-app billing payment methods. So we settled with Google. That settlement, unfortunately, we've been waiting approval from the judge for over a year now. The timeline is we settled, Epic then went to trial, Epic then won the trial. And I think, I don't know, but ironically, this long process of figuring out the Epic remedies has actually held the judge up on just accepting our settlement with Google. And so we are eager to put these remedies in place that have already been agreed to by Google, particularly as this appellate process goes forward. Presumably they'll go to the Supreme Court, so that's unfortunate because we've got a whole lot of money that Google's already paid to give back to consumers based on how they've improperly run the Play Store. We have the judge's overarching concern that he's expressed is that he doesn't want conflicting obligations to be imposed on Google from the Epic injunction and our settlement. And we have a filing we're putting in next week to explain to him why they're not in conflict. They're complementary. So we certainly hope those remedies will go into place. And if the Epic's remedies also go into place, that would be great as well, but one doesn't flip the other.
Michael Kaitis, the Justice Department actually intervened in the Epic appeal to argue against some of the things that Google has been arguing there. I want to talk a little bit about why the Justice Department has been concerned about some of.
Right. Well, I mean, I think this was covered. Let me just put a little finer detail on it. Right. I don't know how many people are lawyers. Yeah. So, right. So lawyers will get this. Liability and remedy are different. Right. There's a large body of law on remedy, right? And on liability, we generally, in general, the thumb is slightly on the side of the defendant. Plaintiff has the burden of proof. Things are close. Plaintiff probably loses. All of remedy law is once you find liability, then the thumb is on the scale of the remedy because you're trying to fix harm, right? And so the law of remedy does not start with thinking about whether the specific act or practice doesn't start at neutral. It starts with there is a problem. And in antitrust law, and I don't think this is all that different from general remedy law, is that there are four sort of things a court should be thinking about. First thing is you should stop the conduct that's a problem. Okay. Second thing is you should restore the market as reasonably as possible to a competitive state. The third thing is you need to try to figure out how to deprive the violator of what of their ill-gotten gains, essentially, so that they don't benefit from the anti-competitive conduct. And fourth, prevent future violations. That's a pretty broad mandate for the court. Now, court can think about whether it's administrable, whether it's going to work, whether it cause harm. That's all on the table. What Google wants to say, and what the defense bar's argument du jour is that you can't order anything that isn't itself correcting the violation. So what they want to say is, well, when we said there were 4 ideas, principles to fashioning a remedy, we didn't mean that. There's only one. The only thing you can do is stop bad conduct. Maybe you can, on the edges, modify it, but where this really comes, and we're just to sort of expand a little more, right, where this hits the head on the Google case is, they then say, look, there is a substantive rule in antitrust law, for the moment, pretend that they're reading the case law correctly, that says that you really, if you're a monopolist, even if you're a monopolist, you don't have to deal with your competitors. So therefore, because it is always legal not to deal with your competitors, you cannot order a remedy that requires dealing with your competitor. But that has totally untethered from a century of antitrust remedy law that says, wait a minute, this isn't about just stopping bad conduct. It's about making conduct competitive. It's about depriving a monopolist of their illegal position. And it's about preventing future harm. And so that's why we intervened, because we found, I think, that the Google's argument was it's not just about even the specific case, it would be about gutting remedy. And it's hard enough to win an antitrust case on the merits to then have to re-argue every single remedy as itself addressing a specific anti-competitive act would essentially gut the antitrust laws. And I mean, the way I sort of thought about this is, look, right, the most famous antitrust case in American history is probably the AT&T case. The remedy there was divestiture, which would, by Google's argument, divestiture would never be a remedy in a Section 2 case unless it was an improper acquisition that led to the monopoly. And it's just a little frustrating, perhaps you've picked that up, that that the courts are having to deal with these sorts of arguments that are just facially would eviscerate Section 2 of the Sherman Act.
Yeah, I think it's worth underscoring when this happened. So the DOJ was at the oral argument for the appeal for Epic, which was well over a week or two into the whatever week we're on now, the Trump administration. What happened during the Trump administration that a DOJ person was arguing to the Ninth Circuit, don't water down remedies case law. So, you know, to whatever extent those tea leaves mean anything, it is at least encouraging that that is still happened.
I would just add this refusal to deal doctrine defense that comes from this case Trinco is being used literally in every case we're talking about today. So, you know, Apple has raised it in the US v. Apple case. In the Facebook case, it was one of the grounds by which our suit was dismissed. In Epic, we just talked about how it's being raised. In ad tech, it was a defense that was at least denied on motion to dismiss.
That's their primary defense at trial.
And then Google search was also, we had separate state-only claims that were just missed on this document. So you could debate a whole lot about it, but it is being, defendants are aggressively trying to broaden their remedies. Originally, it was conceived of only applying to competitors, and now they're saying it applies to any third party that they might not want to deal with, which is what every tech case is. It's about different or limited or narrower access to third parties on the platform. So defendants are consistently saying, essentially, you have a complete legal bar. They should just miss a claim at the outset.
So it's gone so far that the Department of Justice has a case against Visa that involves how Visa, its role in controlling the fees on debit cards that preventing competition for those transactions. And we have the government has a Section 2 claim, but it also has a Section 1 claim. And Visa has asserted that the refusal to deal doctrine applies in Section 1, which makes no sense because it's an agreement. So you're like not like refusing to deal. It's an agreement that's anti-competitive. Like it's how you're dealing, but like if it, you know, it's some, you know, if you can't be liable for not dealing with someone or with dealing with someone, there's not a lot left in that Venn diagram that is not.
Well, and you can't be punished in any meaningful way.
Right.
And the same, just the same. So this, I mean, you're right that it started out in Trinco. It started as a recognized the right perhaps to unilaterally choose who you do or don't deal with, but it's now being argued that it also applies to the right, yes, to contract. And it also came up in this Fubo case where Fubo was this small sports streaming service that was challenging a joint venture between Disney and two of the other major providers who entered a joint venture. And that joint venture, again, of three companies working together, they said, we have this right to refuse to deal with Fubo. And what ended up happening is that case went away only because Disney bought Fubo, and then they all just dismissed the case. But that was the defense there as well.
Yeah, I'm going to move on to our next Google case, which is the Google case I referenced that where we still do not have a decision. So our discussion may be a little bit shorter because we were hoping it would come earlier this week. But Michael Cadis, can you give us a little bit of an overview of that?
So I'm going to go to the same maneuver I went with on Apple, which is like, if you want to understand the government's case, you can actually just find it in Google's documents, right? So if we think about the way ads work, right, on the web, a web publisher, it wants to sell some space. There's generally a ad server technology, like Google Ads, that helps manage that and sends the ad to a ad exchange, which in theory could be anyone. And then on the others, or no, I'm sorry, that's the publisher. I'm sorry. You got the website. They want to sell some advertising. They have a there's a publisher. This was DoubleClick that sort of manages that inventory and will send the ad space to an exchange, and then there will be a ad process like Google Ads will then bid or manage bids for those advertisers who want the space, and somebody wins. And this is all done in real time and immediately. Like, you know, you type in CNN. Well, nobody wants to buy ads on news sites, but whatever, you type in leather bag, and you know they're all, and you go to level some a Reddit site, and they're all bidding on who almost immediately. I mean, it's a technological marvel, right? And so, right, what has occurred is both the services that manage the websites, the publishers, web space, and managing the advertisers' inventory, and the Google Exchange are all basically controlled by Google. As like a 57%, 65% share on the ad exchange, and close to 100 on each side. And so it would kind of be like if the New York Stock Exchange owned all the stockbrokers who bought stock and all the stockbrokers who were selling. And you would expect in that world that there's a lot of conflict of interest, and that the New York Stock Exchange would be basically taking a massive take rate relative to the services they're providing. And so that example actually comes from an internal Google document. They're like, wait a minute, you know, if we own both sides of the transaction and the exchange, isn't that would kind of be like if the New York Stock Exchange owned everything? Wouldn't that be a problem? And the government said, well, yes, we think that is a problem. And what has then occurred was that Google has engaged in all sorts of conduct to really prevent whether it be other publisher tools or ad tools or exchanges from being successful. So for example, sometimes, I mean, Google changes its conduct a lot, and one of their defenses is, at least their claim is much of what the government argued they were doing. They had stopped, but of course, maybe they've stopped because it's been successful. But they would do things like they would have an internal auction on the advertiser side, and then that's what they would use. Rather than having the bid on the exchange, they would have a mini exchange bid first. There were other things they would do where their exchange would basically get a first take on whether they wanted the ad or not. So guess what that meant was all the valuable ads go through the Google Exchange, and then all the, you know, basically fraudulent spam ads are the ones going to the competitor exchanges, and then Google's in court saying, "Oh no, see, there's like 8 different exchanges." But if Google's basically for 80% of the 90% of the ads is deciding where the ad's going in the first place, it's not really competition. So that is, so in a nutshell, what the government said is that, again, not speaking for the government now, and particularly since there isn't a decision, but essentially my interpretation of the complaint as Michael Catus, private citizen, is look, that Google acquired a monopoly across by owning all parts of the ad stack that dominates, and then proceeded to impose further, those acquisitions are problematic, and then the restrictions it put on and use that diminished the ability for even these, for other innovation to occur, is a Section 2 violation.
Laurel, I think, did you attend the entire trial along with me, or?
I did not attend the entire trial along with you. So if you do want the day-by-day account, go to bigtechontrial.com. There was a law student or recent law graduate who attended like every day of trial and wrote up the play-by-play of what each witness said. usvgoogleads.com also has a very helpful like glossary to all of this ad tech terminology, which gets very specific. But I did attend the closing arguments in Virginia. So just to build on what Michael was saying in terms of background of the case, like kind of the choice that the parties are putting before the judge in terms of how to view the framework of the market, Google is saying, Judge, you should view this as a single integrated ad tech stack where you're just matching different parties together. That makes it a two-sided market that is like the Amex case. And the judge was, during the closing argument, she actually kind of, tipped her hand a little bit in saying, well, initially I thought that was a very attractive analogy, but the more I thought about it, it doesn't exactly map on to what's happening here. Because yes, there is a two-sided market, that's the exchange, but there is also an ad server and an ad network. And the ad exchange, so part of Amex talked about there was a simultaneous matching. That happens on the exchange, but the transactions that are happening on the server and the network are just on the publisher side or the advertiser side, and it's not this simultaneous matching of the two necessarily. So that's sort of the critique of that view. What DOJ has been saying instead is that this is a tying case. And so there are two separate ties that are going on. So one is that publishers are being forced to use the ad server DFP in order to get access to the real-time bids on ad X. And they are also being required to use ad X to get access to the millions of advertisers on Google Ads. So getting access to that demand. So that's the framework that the DOJ is trying to make the judge see this as the lens of the case. So rather than this single two-sided market saying this is a tying case, the other argument that Google has brought up, as we've been talking about a lot, is this refusal to deal idea. The problem for Google with that is that that Trinco line of cases, refusal to deal is refusal to deal with competitors. In this case, it's coming up in the context of like, what are Google's policies with respect to its consumers? And there isn't that same precedent supporting Google about you can just refuse to deal with your consumers in any way you want. Instead, this is a display of market power that you're abusing the rules that you're setting up.
Yeah, one of their arguments that they made throughout the trial was this would require us to give rivals access to our customers, which then I thought sort of effective thing that the Justice Department said in response is like, your customers should actually have a choice. Like if your customers, like they're not your customers, they are customers. And so they should have the choice to do business with who they want, as opposed to being forced to do business only with you. We're going to spend the remainder amount of time talking about the bigger, well, depending on who you ask, Google case, or at least the one that's further along, which is Google search. So Michael Schwartz, you were involved in that trial. So why don't you give us a little bit of a rundown on that one?
This is the case I've been working on for the last 3 years or so. I'll give the timeline briefly and then sort of talk about some of the substance. This case was also filed at the end of the first Trump administration in 2020. Also a bipartisan case filed by DOJ as well as like almost all 50 states. Pretty early on, the case was bifurcated, which means that the first phase of the case was just to determine Google's liability under the antitrust laws. And if so, The next phase, which is where we are now, is the remedies phase, meaning what do we do about it if it's liable? There was a liability trial in fall 2023. That was over like 3 months in the fall. The judge then issued his decision holding I think Google had violated the antitrust laws, Sherman Act Section 2. That was last September. And I'll talk a little more what he said in that. Following September, in November of last year, plaintiffs, the DOJ and all the states jointly submitted what they think is the proper remedy package. Google then filed its proposal a month later in December. We're going to have a trial, call witnesses, put on evidence supporting our remedies package in April. And the judge has already said he expects to issue his remedies decision this coming September. So what did the judge hold in his liability decision? First, he held Google as a monopolist. It's a monopolist in 2 markets. One is the user side search engine market, and the other is the general search text market. So these are, ad tech is about like ads that appear on third-party sites, whether it's CNN, New York Times, Washington Post. This case is about the ads that are actually on Google.com, on Google search engine. You see the ads at the top, ads running down the side, text ads. Judge said Google's had like 90% market share in both of those markets for close to 10 years. The primary conduct that Google's unlawfully used to maintain those monopolies is its exclusionary distribution contracts. So like Google pays to be the default, out of the box default, almost everywhere you might want to, any device you might use. This is like most pronounced in mobile. It's true also in desktop, but in mobile, I mean, you have Android or you have iPhone, that's it. On Android, Google requires as part of the contracts that its Android partners make Google search the default. It's pre-installed the Google search app, and you know that is the out-of-the-box default. On Apple iPhones, of course, they've had this agreement with Apple where Safari defaults Google search, and that's been in place for at least 10 years. And as of a few years ago, it came out they pay Apple $20 billion a year to keep the default. And the judge found as a consequence of this, it has impinged competition greatly in these markets, deprive potential rivals of the user scale they need to improve their search engines, and it has harmed advertising markets because like advertisers follow users. Like they won't advertise on a different search engine if they don't have enough users. So there's a negative feedback loop there. So let me say a few words about the remedy that we proposed to the court, and we hope, so we proposed it. I will say there's going to be a revised proposal going in March, which is what we're actually going to argue for the court, but I'll say what's in the one we submitted in October. And there's 4 notable components. The first is distribution. So this is basically restricting or ending these contracts that I talked about. So preventing Google's ability to pay to be the default in all these ways, which we hope will encourage all these partners to look for other means of distribution, of partnering with other search engines. It will increase the users on those, which should increase their quality. The second is divestiture, and the Chrome divestiture got a lot of attention. This is essentially also a distribution remedy. Obviously, Google owns the Chrome browsers, which defaults to Google, and that's not by contract, that's because they own Chrome. And the Chrome default is a huge part of search on the internet. So like 20% of all search queries is people opening up Chrome and running a search on Google. So our remedy says Google's got to divest Chrome. As long as they control Chrome, they're going to find ways to preference Google search on their own browser. The third category is data sharing. And so here the judge made extensive findings that like over its 10 plus years of monopoly, with all these more users, Google's accumulated a massive data advantage that allows them to improve the quality of their search engine that rivals just can't keep up with. And so our view is in order to jumpstart competition, like you got to share some of that ill-gotten data and information. So there's index sharing remedies. There's like search results and the search signals that Google gathers to improve search results and knowing what people click on and why they click on it, how to rank things and when to put things has to be shared. And there's syndication of the search results and some of the ad results that Google shows. And the fourth category is public education. So we're asking the court to require Google to fund a public education campaign. And the thinking here is mainly, so the judge found one of the many entry barriers is brand recognition. Like literally to Google something is to like search on the internet. So like people know Google and nothing else. And that's also perhaps ill-gotten based on its monopoly conduct. So we think it's important not only to open distribution and provide data, but to educate the public about this decision and about the different options and increased competition that will be going forward. So that's what we're asking for. Google has a much narrower view. This came up before. I mean, their view is just this: you can tell us not to do the bad conduct, but nothing else. And their interpretation of what is the bad conduct, the judge found is quite narrow. You know, so all they would ask the judge to do was limit certain tying arrangements, meaning saying we can't package the Play Store with search, we can't package this with this with this, but sort of fundamentally, they wouldn't be prohibited from paying anyone any amount of money to make search the default anywhere. And to us, like, that won't change anything. Not to say nothing about data sharing or anything else to actually address the scale gap. So those are the proposals on the table. Of course, the judge could do any combination thereof or whatever he decides to do. But that's what we'll be, putting on trial and arguing about in a couple months.
Laurel or Michael Katis, if you want to have comments on the remedy or the trial.
So I'll add that I think all the parties are very aware that this needs to be, that AI is a big issue here. That was part of the liability phase that Meta talked about AI in that, and that AI is becoming an important access point for search. So the remedy has to look not just at kind of general search as it existed in the past, but also look forward to what is happening with AI. As I recall, I think the initial proposed remedy had something about banning investments and acquisitions in general search and AI as part of that. So we'll see if that remains part of that. But another thing that I think that we need to think about is that in all of these cases, because litigation in the US takes forever, this will inevitably be appealed, probably all the way up to the Supreme Court if Google is unhappy with things. And during that time, what is going to happen to the market and what do we do about it? So is there going to be some kind of interim relief? So parts of the remedy may go into effect now in order to stop harms to the market and to allow innovation to continue with startups that might otherwise be hurt by Google's market power. And what might get stayed. And I think, it is fairly likely that the judge would try to stay any divestitures, but, things that are more like a ban on, acquisitions going forward. We just saw that, Google is continuing to be very active in striking deals. It just made these big investments in Anthropic, other things like that. So I think that needs to be a consideration in what happens with the remedies phase. So that's very important in looking at this as, an inflection point in, very rapidly evolving technology. And if we're going to truly preserve, the status quo and not let the market get, even worse or let this opportunity bypass us, then we need to be thinking about that at this phase.
One other thing I'll just mention that I found particularly interesting is looking at the remedy and then talking to various people about it is one of the reasons that Google and Microsoft have such a lead, I guess we could say, in AI is because they are search engines. They have access to all of this underlying data that you need to help build a large language model. And websites, it's actually pretty expensive for them if like everyone in the world who wants to build a large language model scrapes their website, because every single time those people are accessing their website, it costs them money. So if instead AI startups could, for example, get access to the Google data that they are scraping, it would help a lot of those startups sort of get a leg up on starting their own LLMs and things along those lines. So we heard from a lot of like AI startups that they were sort of pretty happy about the inclusion of some of this in there because they could, it would give them access to some of the data that they can't get right now.
I just say a few words about AI?
Yeah.
So, because the sort of splashy ChatGPT announcement happened it was shortly before our trial. And obviously ChatGPT partnered with Microsoft, and Google was eager to argue like market is changing, everything's changing, judge, don't worry, competition's been restored, whatever might have been stagnant before, everything's being shaken up now. And And I think we were able to persuade the judge, like this point that ChatGPT is wonderful technology. I mean, AI is wonderful technology, but it fundamentally relies on that underlying data to train itself. And so this very scale issue, like, doesn't go away.
And that connects to the ill-gotten gains principle that Michael has brought up several times in terms of what remedies need to do. And some of this scale and networks effect and data was ill-gotten. So that plays into the remedy thinking.
I can also say a few ways how we're thinking about AI to like future-proof the remedy. Because again, we don't know how things are going to change, but we try to predict it. So one is like how you have the input of your search, how a user conducts a search, where you might, previously go to google.com and type in a query. Now you might, I don't know, open up the Gemini app, or you might just talk to your phone or something else. So we're trying to be thoughtful that anywhere you might search access points was referred to, anywhere you might run a search, even if it's like looks a little different, fundamentally you're doing the same thing, that ought to be included within the remedy. Second way is the output of the search. So like traditionally you get like a result page with all these links on it. Already you see like the AI module on the top, often on Google and Microsoft and others. And it's happening now, and soon you don't see a list at all. You just get the natural text result. In our view, like if you enter a general query and you get results, whatever they look like, those are still the same thing. And again, they're dependent on the same inputs, so they ought to be remedied the same way. If not, it's a way, essentially just things change in a superficial way, and Google would evade a remedy. And the third way is on-device AI. So like some amount of the AI computing is installed on the devices, and currently they're rather resource intensive. So we're concerned about Google contracting or requiring its Gemini on-device AI as either a contractual or practical way to crowd out other on-device AI, which may in turn sort of encourage or require those device manufacturers to still preference or default to Google search. So that's a third way to just looking at AI.
So I just want to take it back. Okay. That was all throat clearing, so I'll ignore it. For the last 2 days, we've been talking a lot about how to deal with these problems and challenges the DMA faces. And I always feel as I listen to these conferences and these issues is, right, the challenge on litigation is it takes forever and courts are not great at remedies. But the challenge with regulation is, oddly enough, the regulated industry tends not to be particularly interested in solving problems. And in fact, generally, their strategy is to find problems with any potential solution. And I think we could, to the degree you want to be optimistic, be at a critical moment in which the litigation in the United States may have a positive spillover across the world, right? We already know Google has been found to violate Section 2, at least at the district court, in the search case. Knock on one, spit 3 times around. Let us say it could be that even before Judge Mehta is deciding the remedy, it may be that they will be found to have violated Section 2 in the ad tech space. I don't think there's ever been a situation where a monopolist has been faced with a remedy after 2 negative liability findings. And I would think that there's a very good chance in that world that the bold remedies will be much easier, even for a judge like Judge Mehta, who's known for being fairly small C conservative, or even Judge Brinkema. Again, I'm not jinxing anything, but having said, geez, you messed up in search, and now I'm in front, I got the same problem. And I think there is at least an opportunity that that actually brings a Google to the table, because all of a sudden they may realize that effective regulation of the types that the DMA is trying to, they may all of a sudden see that as the best of the worst, the least bad alternative they face. And to say that I'm not totally just being optimistic, because Lord knows I need something to be optimistic about. Look, that's what happened in AT&T. It was not until Judge Green hammered AT&T and made it clear that if they wanted to go to trial, they were perfectly free to go to trial. He hated them. He thought they were monopolists. He was going to rip them to shreds if they went to trial. That all of a sudden AT&T ran to Congress and they ran to the FCC and they were like, wait a minute. No. You guys got to regulate here. All that stuff we said you can't do, you really need to do it now. My other example, which is not in the tech space, but since I love pharma and just humor me, right? For those of you who don't know, the United States' pharmaceutical approval process, what created generic drugs, which are much cheaper than branded drugs, was this bill called the Hatch-Waxman Act. And the story behind the Hatch-Waxman Act was Senator Hatch, Republican, trying to pass a bill to really strengthen the IP protections of the brand industry, and passes the Senate, and it comes over to the House, Democratic controlled. Henry Waxman, Democrat, figured out that actually the Republicans had messed up and didn't have the votes to pass it, and he got them to bring it up. And the Democrat, a little bit like there's a West Wing episode like this, the Democrats killed Hatch's bill, and then all of a sudden, for 20 years, the branded companies have been saying you cannot have generic drugs. If you have generic drugs, people will die. Lots of people, millions, in fact. And then all of a sudden, they weren't getting their patent term extension, and they had to go to Henry Waxman, and they had to negotiate. And we now have not that the pharmaceutical markets are perfect, but there is something to be said that I think bold positions in litigation in the United States, regardless of where we end up, may actually foster better policy results across the world.
Yeah, and two comments on that. So one is that because there are parallel cases, although in totally different markets, we could have a situation where there are multiple technical committees that may practically need to coordinate with each other. And that is something that, we'll see to what extent the judges proactively think about that. What kind of communication can there be? And also, can there be communication with regulators in Europe? Because I think that was an issue during the Microsoft case as well. What kind of communication could that technical committee have with Europe? And so that may be something that may play into the actual remedies and search and hopefully ad tech.
So that was, just to be clear, Mike, that was my be bold, continue to be bold.
Okay.
Yes, go ahead.
No, I was gonna make a technical committee point.
Go for it.
So as this, we have asked the judge to appoint a technical committee of 5 experts, some chosen by Google, some chosen by plaintiffs, some chosen by themselves, to carry out the remedy. It's a lot of complex parts of it that they'd make calls, and then there was disputes that would go to the judge. In the Epic case, the judge already put in place technical committee. And this all goes back to the Microsoft case where there was a technical committee that did just that. There, it was put in place as through Microsoft settled with the plaintiffs post-trial before the remedy was put in place. Among other things, in the Ninth Circuit, Google argued that it violates their due process rights to have a technical committee forced on them. And I don't know anything, but I can expect they would make the same argument when we are seeking a committee. So that is one of, there were frankly many arguments.
The other sort of color commentary I will offer in terms of litigation changing the mindset of big tech. Another thing to keep in mind is that across all of the Google cases, Google got in trouble with the judges because it destroyed evidence. And this wasn't just like a couple of engineers not preserving emails. It was that their former general counsel, now chief public affairs person, Kent Walker, devised this program, Communicate with Care, that had slides saying, here are the ways that we are going to make sure that, we're not going to share information with adversaries. We're going to have a program where you should default towards communicating over chat because chat is not preserved in the same way that email is. So they had an auto deletion of all of their chats. And when there were, and that continued even when there were litigation holds, And they just sort of said, it's up to each individual employee to decide whether to preserve the evidence or not, even though Google did kind of have a switch to say, yes, we could have just automatically preserved all of this. So the judges, the multiple judges in each of these cases, in the search case, in the Epic case, in the ad tech case, each of these judges separately expressed a lot of shock. They varied in the degree of sanctions they have imposed on Google, but it is certainly something that impacts their view of Google's credibility, and that may impact the case in a lot of ways, and in some ways may make the cases more difficult to appeal because it makes it harder for Google to say, well, you didn't meet your burden of coming forth with evidence, if the other side can say, well, you destroyed the evidence. So
we have just a couple minutes left, so I wanted to open it up for audience questions. We'll go to Megan first, and then.
I just had a question about if the government might have any regrets with not filing more cases in the rocket dockets, which is not just Alexandria. You also have the Northern Southern Districts of California, Northern District of Georgia, Western District of Wisconsin, and Texas, but I understand why you wouldn't go there. It seems like that is an obvious choice for many of these antitrust cases. And I'm not sure the thought process to not go that path.
So, the minute I do that, I'm gonna get caught on a hot mic. So I'll just allow you to. What I was saying is, again, not commenting on decisions on any specific case. Look, I mean, venue is both a substantive and a tactical decision, and so being in a docket that moves fast is attractive. You have to weigh that against whether you're going to face a motion to transfer. Do you want to deal with the motion to transfer? Do you want to take a risk? And so also it may depend on the case, the substantive case law. There's, if you are in rocket docket in a district, for example, that has really terrible case law, it doesn't really help that you're going to get to judgment quickly. So, like, I think we did take advantage of the rocket docket in the EDVA because we thought venue was appropriate there and that we were comfortable with the case law. But it in the end has to be one thing among many factors that you weigh.
I don't know why the search case was filed in DDC, but I will say the Microsoft DC circuit decision was a cornerstone case that we relied on. So it kind of makes some amount of sense to file there. So you get that binding case law. And in fact, Judge Meadow relied heavily on that decision when he issued his ruling.
Yeah, one quick question. I think it's two questions in one. Just because there's so much going on and we don't really know what the government is going to do next, we don't really know how many of the tech oligarchs are, whisper into the government's ears. My question for Michael S. is, what is your sense now that you're out of the DOJ about the DOJ continuing to be bold with the cases that we just discussed here, not only on the remedies case for the search case, but also on the remedies section, stage, hopefully we get there on the ad tech case, and also thinking about Ticketmaster. Can we expect that all of the, there'll be action that'll be pursued there? And let's just say that it is a scenario that the DOJ ends up seeking any sort of settlement. Now the question goes to the states. Would the states, can they technically continue to pursue the remedies on a separate trial? And is there political will there? And would you do it if that comes to be the case from the DOJ, if they drop the ball?
So I like to consider myself an antitrust expert, not a political science expert. And so I think I don't know what world we live in anymore, to be honest. I think if we look at Gail Slater, the nominee to be AAG, her record, it is outstanding. She is as qualified to be AAG as anybody in the country. I worked with Gail back at the FTC, her bona fides and being concerned about dominant power in the technology markets certainly suggests to me that she herself will be aggressive. There is reason to look at that the antitrust continues to be maybe the last area where there is bipartisan support, at least on the tech issues. Let's just focus on tech since that's what you asked. So it would not surprise me at all that that's the world we live in, that actually this transition looks unlike any other part of the government, and the department, maybe does things slightly differently than Jonathan would have done, but like in the broad sense, very consistent. Look, is there a world where, as people are concerned, that decisions are being politicized, and if would point to the tech CEOs all being on the stage at the inauguration, that will somehow have an impact? That's well above my pay grade, but I wouldn't I don't know. So I just choose to, I think, try to be optimistic here that, that the division is in very good hands with Gail.
So I guess I'll just say that this point was raised before, like my office supports going for bold remedies. Like the remedy here we think is appropriate, but also robust. I don't know anything about what's going on in DOJ, like what their higher ups may say, but I'll just say, so two data points. One, this case was filed during the first Trump administration, and we sort of hope that counts for something. And the other one is our coalition is like truly bipartisan. Like I work with people from the Tennessee AG's office, Nebraska AG's office, Ohio AG's office, like people in my office and other divisions. Like it's amazing to them how much we work with that states, because they're fiercely antagonistic to them in other areas. And yet antitrust may be one of the remaining areas. We're still working great with DOJ on this. So I can't speak to what their leadership may or may not decide. But to your other question, absolutely we're not beholden to what they decide to do. We can still go for the same remedy package. An example of that is the Sprint T-Mobile trial. So during the first Trump administration, DOJ reached a settlement to permit the merger. A number of states, including New York, nonetheless brought litigation challenging the merger. Didn't succeed, but that's an example of DOJ made one call on an antitrust issue and the states made a different call.
Yeah, and I think that does put meaningful political pressure, knowing that the states might push back and be very public, that there is a difference of opinion.
Yeah, I mean, the other thing we hope is DOJ has taken a public position on what the remedy ought to be here.
Right.
Doesn't necessarily mean well, I hope
We'll
so.
see.
Yeah, not to say they won't do it, but I hope so.
Felipe.
Yeah, I wanted to build on that and ask about legislation, actually. So, U.S. failed to pass meaningful antitrust legislation on substantive grounds on the federal level, but there are a couple of states trying to pass legislation at the state level, right? New York being one of them. So how do you think about this reflection? How far can the states go outside of the federal government, and at what level does this trigger, dormant commerce clause or some kind of higher up political powers that would say no, you basically cannot have a totally independent monopolization standard that goes beyond. How do you reflect about that? I'll be very curious.
So it was said earlier today, there's a pretty strong law that antitrust reform is not an area where there's preemption. That is to say, states and federal government are co-enforcers of both the Sherman Act, Clayton Act, and yes, there are also state antitrust analogs. We have the Donnelly Act in New York. And it's true, there's legislation that's been pending for several years that would broaden some of these standards, make it a little easier, longer, higher penalties, those kind of things that we hope will get passed. But we already enforce the Sherman Act. We already think our Donnelly Act is sufficient to go after all these violations.
Yeah, and we heard Paula Blizzard talk about California considering amending its act to include both just having a single monopolization standard in the first place, but also having an abusive dominance standard, which New York is also trying to do. So that would be something that could be stronger than federal law, and states would be able to enforce if those go through.
It came up in this Kroger-Albertson merger. There was both an FTC challenge and a separate Colorado on its own challenged it. And one of the arguments that Kroger-Albertson raised against the Colorado one was that it ought to be consolidated, or just that it should be dismissed because it was the local effects in one state can't possibly be a reason to enjoin a nationwide merger. I don't know if that argument will ever get, like, I don't know if that the judge will rule on it. He's basically said this case is moot because they've already, but anyway, that was an argument they raised. Like, I don't think it was right.
Well,
but
I mean, the Clayton Act says in any section of the
correct,
country,
correct,
so.
yes, yeah.
Wait, it states a section. The one place where this came up, and unfortunately I don't remember, there had been for a long time a big issue in antitrust law in the early 2000s and 2010s were these patent settlements. The Supreme Court issued a decision, FTC versus Actavis. I believe California tried to pass a stronger bill that the Ninth Circuit actually said did violate the Dormant Commerce Clause. So that I think there is an open question. And then when you add the relative uncertainty of where the federal judiciary at the highest levels is interpreting their own doctrine.
I will just point out that that had to do with IP, which is federal only. Joe has a question.
Yeah, thanks everybody. Awesome panel. I hope this is an on-point question comment. So, you know, Michael K., when you mentioned like how many of you are lawyers, I was like, oh, I'm a lawyer. And when I was in law school, my dream was to do amicus briefs. And I think that there's a lot of really important issues of the public interest in all of these cases. And I'm also well aware that judges too frequently say that they don't understand technology. They don't want to get involved. And so it seems like all of these cases, there's room for amicus briefs. But I've been particularly just sort of impressed upon, I think it's Paul Gibbons' amicus brief in the Epic case, where he highlights the fact that Google and really all these companies have these amicus machines where they're just sort of churning out amicus briefs that cross-cite each other, and that then the defendant can cite as a way to sort of flood the zone. So I'm just sort of curious what folks' thoughts are on the merits, values, and what we do about amicus briefs. And
Let me put in a plug for the the Judicial Conference, which doesn't tend to do very much, but right now has a open public comment period about this exact question, whether they should have additional disclosure requirements for amicus briefs filed in federal court. So if you have a strong opinion on that, you might submit a public comment to the federal conference.
So that docket, I think, is open until February 17th is the deadline. So look at Judicial Conference and so the existing rules are, there's very little disclosure that is required. Like, you really can't tell who is funding an amicus brief. Definitely check out that amicus brief in the Epic case. I think it was Paul Campbell. It's from Court Accountability is the nonprofit that wrote that or co-wrote that brief. But yeah, I mean, it's pretty, so it goes both into kind of the history of amicus briefs and, you know, they're originally supposed to be a neutral friend of the court. They have evolved into something very different. And now there's kind of like a cottage industry of especially elite law firms who kind of coordinate and you know, it's kind of a way of parties getting around briefing page limits, or arguing things, you know, if they forgot to argue something or didn't come up with an idea during the case. It's a way of later, oh, they get an extra bite at the apple because they're doing it circumventing. And, you know, you can make these amicus briefs kind of create an echo chamber where, you know, someone who's accepted, you know, computer scientist who's accepted grants from you in the past is going to say, oh, yes, this remedy is going to cause all of these, you know, security and privacy issues. I'm not going to tell the court that I'm funded because I'm not currently required under the rules to do so. So it appears like it is a neutral expert that is creating this echo chamber. So there is a huge problem.
They also sometimes are a way to like get in facts or evidence that like aren't tested in discovery,
Right.
or
Exactly.
violate evidentiary rules.
Yeah.
Or just add, I think this is a specific example of a larger problem. So if we go back to state of Ohio versus American Express, the Supreme Court there cited a tremendous body of economic literature. Sorry to take a shot at my France, but from this, most of it done by the economists in Toulouse, and turned out it was the credit cards companies that funded all the work. Oddly enough,
To invent the concept of two-sided markets, is that what?
But so that this is a problem, at least in theory, one would have, so I think increased disclosure is really important. One would have thought, and again, apparently everything I learned in law school was wrong, that the whole point of why we have appellate courts only looking at what's in the factual record is precisely because everything any factual things coming in after that have not been tested, but apparently that's more of a guideline than a rule. But I think it is a very serious problem where, cases basically can be turned on their heads based on arguments or academic literature that wasn't really part of the process.
Yeah, and part of the judicial conference's proposed revisions, that it notes kind of the history of how they got to do this, because Congress was going to maybe make them do something stricter. So they wanted to kind of head that off at the chase. Also, the Supreme Court asked them to look at the review, because the Supreme Court is going to look at what the judicial conference does for the appellate courts in terms of, okay, do we need to change our own rules? So this could have impacts up to the Supreme Court level at some point.
We are at time, so I just want to thank everybody for coming today, and thank you.